If you are involved in a lawsuit, either in district court or a superior court, then there's two types of real estate liens that you need to be aware of. The first is called an attachment, and the other is called an execution. And they're issued in different ways, but essentially they work in the same way in that they put a lien on real estate. So a writ of attachment is something that is asked for before a hearing or a trial is scheduled or is had. Right? So essentially one person will file a lawsuit, and then he will ask the court to issue an attachment to place on the other side's assets, especially real estate. The concern here is that the person, the defendant, might sell off his real estate or get rid of it before there's a judgment against him. So this requires a hearing. The court will require a hearing before they issue a writ of attachment, and the person asking for the attachment needs to show that there is a likelihood that he will succeed at trial. And if that can be shown, then the court will issue the attachment. Now, an execution is granted to a party who wins a judgment after a trial. Right? So you go to court, you have your trial, you win, and then the court will give you an execution, which you can then use to place a lien on the losing side's real estate. Right? So the attachment and the execution function in similar ways. They are both good for 6 years and 90 days unless they're extended. And the judgment, if you get a judgment, it's good for 20 years, but the execution needs to be renewed, like I said, every 6 years in order to have it encumber the property. Right? So if you have questions about real estate, civil litigation, liens, whatever it may be, please contact me, and I'd be happy to work with you and help you out.